And with that, I will call the first case, in re Petition of Attorney General for Subpoenas. This is a mini oral argument on the application. You each have 15 minutes, counsel. Ms. Grukowski, you can go first and try and reserve time if you like, and Mr. Bostic, you will go next. You may proceed when you're ready.
Can I say
May it please the court?
1 second. I have a rebuttal from Justice Markman.
Chief Justice, thank you very much for the kind remarks. It's very nice of you to say those. It's been a blessing to serve on this court, a great opportunity to serve the public as we all have had the same opportunity. But I take it this doesn't mean that we won't have to slug out these cases today during our conference. Is that right?
We'll get them done. We'll just, get them done in the next few weeks.
Well, thank you again for the kind words. I appreciate it.
Absolutely. You may proceed, counsel.
Okay, thank you. May it please the court, Assistant Attorney General Michelle Wagner Gutkowski, on behalf of the Department of Licensing and Regulatory Affairs and the Department of Attorney General, I would like to reserve any remaining time I have for rebuttal. Respectfully, federal and state law protect the confidentiality of patient records, but it also recognizes that in order to protect the public health, safety, and welfare of the public, that health regulatory and law enforcement agencies need to obtain patient records as part of an investigation of a provider for criminal or practice-related misconduct. That's because there's a rule in healthcare that if it's not documented, it didn't occur. As such, patient records are often the only effective means for investigating a healthcare provider for criminal or practice-related misconduct. Here, the Court of Appeals decision rendered in this matter unnecessarily impedes and frustrates health regulatory and law enforcement agencies' ability to thoroughly and quickly investigate substance abuse treatment providers for criminal or practice-related misconduct. In this case, the Board of Medicine authorized an investigation into Dr. Proctor. That investigation identified 11 patient records that it deemed relevant to its investigation. Believing that those records may contain references to substance abuse treatment, the department petitioned the Ingham County Circuit Court for an order of disclosure of those records in accordance, with the Public Health Code and 42 CFR 2.66. 42 CFR 2.66 is fact specific. It specifically allows health regulatory and law enforcement agencies to obtain ex parte orders for disclosure of substance abuse treatment records when you are investigating a substance abuse treatment provider. It's important to note that the department's petition was not reviewed by the Ingham County Circuit Court in isolation. The Ingham County Circuit Court reviews department investigative subpoena petitions on a weekly basis. These are for records that are non-substance abuse treatment, but regular patient records needed as part of department investigations. They've been doing so on a weekly basis and regularly since the mid-1990s. As such, the Ingham County Circuit Court is well versed with and keenly aware that the Public Health Code affords strict confidentiality protections to those patient records as well as the department investigations, and that the department has been handling sensitive patient health protected information without incident for more than 40 years. For the reasons that are more fully set forth in our brief, the department's petition, the Ingham County Circuit Court's order of disclosure, and the court's ruling from the bench satisfied those statutory and regulatory criteria for issuance of the disclosure of the substance abuse treatment records requested in this matter. And we would respectfully request that this honorable court grant our application and reverse the Court of Appeals decision in this matter. Thank you.
Thank you, counsel. Justice Markman, I think back to you. You get to go first.
Yeah, Ms. Wagner, thank you for your argument. The petition seeking disclosure here stated that the disclosure was the most effective way to investigate the matter at hand. Is that really a relevant observation when the standard requires the court, the legal standard requires the court to find that all other means would not be effective, not that the disclosure would be the most effective way of providing the information? am I putting too fine a point on that language, or is there some basis for me being concerned that by concluding that the disclosure here was the most effective means is not quite tantamount to saying that all other means are not effective?
No, Your Honor, you correctly note the distinction that's referenced in the statute, and it doesn't provide that other to establish whether other means are not available or would not be as effective. However, I think that the point to make is that the department was advising the court that the only means that were effective for investigating Dr. Proctor are his patient records. And I think that that's consistent with the case law. In the In re August decision, that federal court held that it was appropriate for the grand jury in that case to subpoena the patient records. And in their motion, they specifically just stated that the patient records are needed to provide material evidence. So I think that the point is that although the department did not use the magical language of the statute in its petition, its intent was clear that there is no other effective means that are not available for investigating Dr. Proctor, for the very reason that his own documentation demonstrates the care that he provided and whether or not is legally sufficient.
Thank you, counsel.
Thank you.
Justice Zahra?
No questions. Thank you.
Justice Viviano?
I have no questions. Thank you.
Justice Bernstein?
Yeah, I guess I just have one question just to follow up on Justice Markman. So it's just to be clear, it's the state's position that there's no other way to conduct an investigation other than the way that you did it in this matter, that there's no other methods, there's no other alternatives, there's nothing else that could be done?
No, I don't think it would be even fair to the investigation or to Dr. Proctor himself to thoroughly look at the kind of care that he was providing, because he needs to, as I said, the rule in healthcare is if it's not documented, it didn't occur. So you could maybe get interviews from patients, but they're not as effective, or they would not remember things. They're not quite sure how the treatment was provided. They wouldn't be accurate historians, but the patient records would be. You could look at MAPS reports to see what Dr. Proctor was prescribing pursuant to a MAPS report, but that wouldn't be a true picture because we wouldn't know what information Dr. Proctor had coming in and what his objective data was, the vital statistics, how that patient presented, what his objective findings were, what his differential diagnosis was. So it wouldn't be a fair assessment of whether or not he was providing care within the standard or legally. And so to disclose the patient records for the investigation protects both the public, but as well as Dr. Proctor, so we can have a true picture of what kind of care he's providing and whether it's within the standard of care. And so this provision allows for that. And specifically because we're not looking at the identity of the patients, we redact all the patient identifying information. Their identity is not crucial to the assessment. It's looking at what he documents is what he has presenting in his office and how he responds to that information.
Thank you, counsel.
Thank you.
Justice Clement?
No questions. Thank you.
Justice Cavanagh?
No questions for me either.
Counsel, you may reserve your time or you can go on. It's up to you.
I'd reserve my time. Thank you, Your Honor.
You bet. Mr. Bostic.
Good morning, Your Honors. May it please the court. Nick Bostic on behalf of the appellee, Dr. Vernon Proctor. The first comment that I want to make is in response to counsel's argument of the 30th Circuit Court's review history of departmental records. That's really not in the record below. It's not really before this court to assess. It wasn't really argued to the Court of Appeals. So I'm not quite sure that that's an appropriate consideration. And even if it were, the 30th Circuit Court did not incorporate any of that into its analysis. I think probably the biggest concern the department has is they want to avoid any type of hearings. They want to avoid any type of review of what they're doing. So I'm going to focus on that first. And it's true that some of the earlier pleadings I made in this case may have suggested that Dr. Proctor's position was that a hearing was mandatory, that some type of hearing was required. I'm not asserting that now, especially not that a full open evidentiary style hearing is mandatory. And the reason for that is because if Congress wanted that, they probably would have said so in the statute. And if the federal agency would have wanted it, they would have probably put it in the regulations. But Congress used the words, "the court shall weigh," and then expressed in very clear terms 2 factors on the disclosure side and 3 factors on the non-disclosure side. So as lawyers, we all know that when Congress uses a term of art, it understands how the courts apply it. It understands how it's been interpreted. So it's Dr. Proctor's position that when Congress says the court shall weigh, we can safely understand that some sort of factual information has to be presented so a trial court can comply with that directive. So Congress also knows that trial court decisions are subject to appeal. So rather than make this an agency decision or a licensing board decision, they made it a court decision. And lastly, Congress knows that court decisions, when they're reviewed on appeal, the record, the analysis, the application of the facts to the law is what is reviewed. So by doing it the way it's been done here, all of that is eliminated. There is no way to review it. So the Court of Appeals remanded to the trial court, and they did in fact mandate a closed hearing. But I want to urge upon this court that you shouldn't take this application at this posture, because that order in the remand was not done in a vacuum. If you look at the lack of factual detail and nothing but conclusions in the petition, the point is this petition is so weak that the Court of Appeals apparently believed that at least a closed hearing was the only way that this petition should even be entertained. They didn't dismiss it. They just remanded it for further proceedings. So obviously you were going to view that part of the Court of Appeals order as you see fit, but I would just encourage you to take into consideration the fact that the underlying petition is so weak that in this context, that was an appropriate part of the remand order. The other part of the remand order is that the trial court make the required findings. And that's a pretty unremarkable directive to a trial court. So I think that the application of this court's premature in the context of this particular case. So for example, if the Attorney General would, if we go back to the trial court, if they support their petition for the supplemental brief and they present some factual material, a redacted affidavit, some prescription records from the automated system, or an interview, something. But one of the interesting things that I've been focusing on all morning as I was preparing for this argument was the way they characterized Dr. Proctor, his wayward prescribing practices, his abusive prescribing practices, and the implication is that he's prescribing opioids. Well, probably not, because he's a substance abuse treatment practitioner. So he's probably not prescribing a lot of opioids, if any. But they didn't even allege in their petition that he wrote a prescription to any of these 11 patients or anyone else, or what it was for. So when they go describing why they're investigating him, that's all well and good, but they fail to allege that he wrote a prescription for an opioid, which, while it wouldn't necessarily help the trial court weigh the public interest, at least now you've got some factors on the side of disclosure. And then there's the issue in here of a substantial risk or existing threat to life or bodily injury. None of that is addressed. And again, if they would have at least alleged that he wrote a prescription for something that was dangerous, the trial court would have had something to work with. Then, if they do that, the trial court can then decide the parameters of the hearing. Closed session, out in the courtroom, cross-examination, witnesses are on the record. As I pointed out in my supplemental brief, motion practice, if this is considered a motion, courts, our trial courts have discretion to dispense with hearings. If the underlying data and information are adequate, that's exactly what the court rule anticipates.
Mr. Bostic, I'm going to interrupt you and see if my colleagues have questions before we use up all your time. Justice Markman.
No questions. Thank you.
Justice Zahra.
No questions. Thank you very much.
Justice Viviano.
No questions.
Justice Bernstein.
Yes, counsel, good morning. If you could just respond to sister counsel's argument that they didn't really have too many other options other than conducting the investigation that they did.
Well, we don't know whether an investigator has talked to anyone. We don't know if an investigator has looked at the MAPS reports. We don't know if an investigator has spoken to any patient. And the standard is not that their chosen method is the most effective. Now, I understand, and I touched on this, but not in that context in my supplemental brief. If you put together, in other words, you come to a court with a limited amount of information to get a limited amount of records. Those records may give you what you need to come in and get more records. So we simply don't know what it is they're investigating. And I understand where you're coming from, because the argument about the doctor's records, the treatment chart, will tell you a lot. I understand that. But when you don't know why in the first place they're investigating or what the goal of the investigation is, you cannot possibly determine what the most effective way is or what ineffective means might exist in the normal course of an investigation. I hope I addressed your question.
You did. Thank you, counsel.
Justice Clement.
No questions.
Justice Cavanagh.
No questions.
Counsel, you may continue. You have some additional time.
Thank you. If this case goes back to the circuit court and she decides this is the way I'm going to do this hearing, and if she demands steps that the Attorney General doesn't want to use, either because they don't want Dr. Proctor to know the information or they simply don't want to disclose it, whatever their motive is for not disclosing it, and the trial court rules against them, now you have a concrete step that the trial court took for the Court of Appeals to review, and more importantly, for this court to review. So my point is, when the trial court simply rubber stamps the petition and the conclusory allegations in it, getting to this level and using this court's resources is premature. Once the trial court, and of course, again, if the trial court just looks at some affidavits or looks at a written statement and orders the records released, then Dr. Proctor can come back up and this court can decide whether that was sufficient. But in the context of this case, they simply have not given, and neither did the trial court, any justification for this court to put its time into the case. The remand was the appropriate remedy. And again, the Court of Appeals just said a closed hearing. And that's obviously just to further the privacy protections. Court of Appeals did not direct the trial court to have that hearing in any specific manner except to close it. So I don't see the error at this point that justifies this court's involvement. One of the things I wanted to emphasize about a non-disclosure factor, and that is the public interest, is that you can't overlook the fact that Congress has already put the heightened privacy of these records in the public interest category. So if you're looking at invading this privacy for this treatment, the public interest has to go up another notch or two because Congress has already made that very clear. And then I guess the last topic I will touch on is the confidential communication portion. That's not been talked about a lot, but it was briefed. And again, the petition simply alleges conclusory allegations. This is one of those very clear things. And the August case that the Attorney General's office relies on heavily, that specific court said, no, you did not do enough to get the confidential communications portion. So that's another critical part. I mean, it's one thing to let other medical professionals review the work. It's an entirely different thing to let anybody else see those communications between the patient and an addiction treatment specialist. For those reasons, Your Honors, I would ask that the application be denied at this point. Let the remand work itself out so that you have more of a set of parameters to work with to see if there's compliance, where there is some factual information put in there that can assist in deciding if the trial court performed its function as required by Congress. Thank you.
Made my own mistake. Thank you, Mr. Bostic. You have some time left on the clock. Ms. Wagner-Gutkowski.
Thank you very much, Your Honor. I would first note that I would disagree with Mr. Bostic's assessment that the Circuit Court did not take into account its familiarity with the Public Health Code. Initially, when she first began her ruling from the bench, she specifically addressed the Public Health Code and acknowledged that this was a department investigation that was pursuing these records pursuant to its authority under the Public Health Code, and she acknowledged her familiarity with that. Initially, she also correctly noted that the regulation 42 CFR 2.66 doesn't provide for for her to engage in any kind of fact finding. Specifically, it's her responsibility to review the petition and her order for disclosure to ensure that they provide compliance with the regulatory criteria and determine whether or not the department's petition is for a valid reason and the scope is appropriate. And that assessment is confirmed by the two decisions that we've referenced in our brief, which is the In re August decision and the Schinderman decision. Both of those decisions specifically are the only two that are applicable to interpreting 42 CFR 2.66. And in this case, the department's petition specifically referenced that it was investigating Dr. Proctor for controlled substance prescribing practices, and that was only investigating or seeking 11 patient charts. And thus that demonstrated that it was for appropriate reason based upon the case law, and that the scope was also appropriate. We're only talking about 11 charts. And as the court further went through all the factors and referenced the department's petition and the paragraphs in the petition that cited to all the key factors of the regulatory criteria, as well as with regard to her order. I would note that the 42 CFR 2.66 this provision recognizes that health regulatory and law enforcement agencies may be limited in what they may divulge during these proceedings either by law or because it would impact the integrity of the investigation itself. For example, the Public Health Code prohibits the department from sharing anything with regard to its confidential investigation or even disclosing the name of the complaining person who initiated the allegation against the provider. And lastly, would indicate with regard to the confidential communications, no other court has limited the application of 42 CFR 2.63 in such a limited manner. And in fact, if you read the provision 1, as the Court of Appeals has done, it essentially renders paragraph 2, which talks about seeking the disclosures for a patient committing an assaultive crime. It would read that, render it negatory. So we would say that that it shouldn't be interpreted that way as well. And lastly, with regard to In re August, yes, the court found that seeking records for psychotherapists over billing did not meet the criteria under 2.63, and we would agree with that, but argue that's not the case here. We're talking about prescribing practices that are a threat to the patients themselves, given the opioid epidemic, the combinations that they're getting improper medications, controlled substances, and their impact on their health, as well as it's intuitively obvious that impaired individuals out there are a threat to the public health, safety, and improper dispensing or putting out medication, controlled substances out into the streets is intuitively obvious that it's a threat to the public's health and safety. We believe that it meets the criteria for confidential communication disclosure under the regulation. Thank you.
Thank you, counsel. Are there any additional questions from any of the justices? Okay, the case will be submitted. Thank you both.